Good morning. I thought today we'd cover chapter 14. It's a big chapter. It's on personal property, so I thought I'd jump right in. There are two major kinds of personal property, tangible and intangible. Intangible are the things you can feel or touch, my cell phone, my eyeglasses, the shirt I'm wearing, the chair I'm sitting in, the textbook, this coffee mug. These are all tangible. We can feel, touch, they're concrete in nature, and they're movable. What's not movable? Real estate. So that kind of distinguishes between personal property and real estate. But what other kind of personal property do we have? We have intangible. Things like a check. A check is representative of someone's desire to pay you from a third party, a depository institution, for example. Rights and contracts, those are freely assignable. Rights are a type of personal property. Copyright, patent. If I get in a personal injury accident and I'm going to be able to sue for damages, that's also a type of property interest. They're intangible, though. We can't really feel or touch them. There may be documentation that is representative of the ownership of it, but it's not the thing itself. So a lot of us struggle with the concept of intangible. Anything that's intangible is kind of a struggle, right? The book goes into the methods of acquiring it. And what we're going to talk about mostly in business law is purchase and sale. Someone's going to buy and someone's going to sell goods, items of personal property that are movable. Uh, and I do, in the regular class, spend a little time on wills and descent and gift. I will tell you about will just briefly. In Massachusetts, it does have to be in writing. It has to usually be witnessed by two non-interested parties. And basically, you can divest your property any way you wish. You just simply can't disinherit a spouse completely unless you have a prenuptial agreement or the spouse consents to it. Usually, the spouse has a right to take a third of your estate no matter what while you're still married. Obviously, if you're divorced, there's no right to claim anything in a divorce. But what if you and your ex-spouse get along pretty well? You can leave them something in a will. That's the power of the will. Same if you have stepchildren or something like that. They wouldn't have an inherent right to inherit from your estate, but you can put them in a will. You can put anybody you want in a will. I'm writing a very close friend of mine's will right now, and it's very complicated because he has specific gifts going all over the place. And that's the power of a will. Descent means basically distributing your stuff without a will. And surprisingly, the law is formulated in such a way that it often, I don't want to say mirrors, but it relates a lot to what most people put in the will. So most people, when they die, a significant portion goes to their spouse if they're married, and if they're not married, the rest gets distributed to their children in share and share alike. If there's no spouse, no children, you look up and see if the parents are still alive, and it's distributed to them. So if no children, and no spouse, no children, no great or grandchildren, or no great great, and you look down in descent first, then you ascend up to parents and grandparents. Can't find any of those surviving. Then you go out laterally to brothers and sisters and cousins. And I know some of you say, well, what is it? Give me specifics. There's a formula for it, and there's a chart, and it's usually kind of common sense when it really comes right down to it. Gift, I do want to spend a little bit of time on. This comes up a lot with a concept of if you give something and then you regret it, can you get it back? Well, you can always ask for it back, especially if it's in a relationship situation where the relationship goes south and you gave somebody else something of significant value. But is there any obligation to give it back legally? No, it's a gift. A gift is a completed transaction. I hate to call it transaction. It's probably an inappropriate term. But think about it. If I give my friend who I just care about a great deal, some my old snow tires for my truck because he's got the same model, and I bought a new set. And I said, hey, these are for you. These are a gift. I don't need them anymore, and I know you do. And then later on, we have some kind of falling out. Can I ask for those back? Well, I can, but does he have to give them back to me? No, because a gift had all three elements satisfied. What are the three elements of gift? The donor, the giver, wants to depart title to the recipient, the giftee, if you will. Once that person has the power of ownership, usually deliver of the physical object in their possession, or right of possession goes to them, it's done. But they also have to accept, because sometimes someone wants to give you a gift and like, that's the last thing I want. My sister gave me a waterbed once. The worst thing that ever happened to me. I wish I rejected the gift early on. I was with her yesterday, actually. That was part of our conversation. She was saying how nice she was to me when we were younger because she gave me a waterbed in my first apartment. Worst experience I've ever had. So, gift, three elements. The gifter wants to have the present desire to transfer title to the recipient. The recipient has to have it delivered to them in some fashion so they can can exercise dominion or control over it. And then lastly, the recipient has to accept, because no one gives, because sometimes in estate planning, especially like say say I was very wealthy, which I'm not, but what if I was? If I was very, very wealthy and my mother happens to have a lot of money, also a fantasy, but say she did, and in her will she leaves me a bunch of assets, it might make sense for me to reject the gift, because then it might flow down to my children. It might bypass certain tax liabilities that I worry about. So sometimes rejecting a gift makes sense for purposes of having it flow to another recipient that's going to make more for purposes of tax benefits. I'm not going to spend any time in the session or confusion of source. That makes common sense in the book. It's very straightforward. I don't think I test on it. I will talk about creation. Creation is like things like patent. I think patent law gives you 14 to 20 years. I never can remember the rules because I don't do patent law. Yeah, it is in your book, 14 to 20 years. This is an original process or creation of a new item that is unique in its functionality. I mean, that's the best definition I can. The book can do much better. I'm not going to test you on my theme, but I test right out of the book. All my test questions are derived directly from the text, hopefully making it a little bit more clear. I think this next test, most people are going to find a little bit clearer, I hope. So we call this intellectual property. These are intangibles, right? So things like patent, an original process. I was thinking of my friend of mine thought he invented a new type of plunger where it would act as a one-way valve on a compression sort of sack filled with air. You put so much water in the lower portion, then you squeeze the air, and it would only go one way because it was a one-way valve, and it would push down into the trap of a sink or a shower or a tub or something like that. He was all excited about it. Wanted me to do some patent research. That's not my cup of tea. I said, well, let me look into it a little bit. I was telling my father about it when he was alive, and my father was a plumber. So he goes, ask him if it looks like this. And he goes out to his garage and he pulls out something that looked very similar to that already. There's already been invented. And right on the packaging, it says patent number such and such, to warn people, that this item's already been created. And now what if my friend says, well, mine's a little bit different. If the basic function's the same, you can't copy it and just put a little bit of a different sort of style on it and say I didn't copy it all. And even if your act is original, but if somebody else came up with it originally first, their rights are protected, provided they sought and received a patent. And there's a whole area of patent law. Some of you are in the legal studies program thinking about becoming paralegals. Some of you are going to be attorneys. It's a very lucrative practice, very narrow practice, but it's not my cup of tea. But patents usually have to be recorded in the federal patent office. Every state has one. And they do a thing called a patent search first to make sure someone hasn't already invented it. It just never really came into fruition. No one's ever marketed the concept or the idea. But patent law is huge. Another area is copyright, an original song, a musical score, a book, a play, but it has to have an extreme degree of originality. Many stories have an overlapping quality. The same friend of mine that did this new novel Plungeriad, he called me usually after having a few cocktails and said he wants to sue, I think it was Disney or Pixar, over Finding Nemo, the little fish that had I guess one smaller fin than the other, and went through this long journey to return home and all these other things. He actually wrote one for his class he had taught out in New York State about a seagull that had a similar problem before Finding Nemo came out. The problem is those stories are kind of epic in nature. I should say nature, in history. There are many stories of either people or animals or entities that suffer from a great deal of underdog status because of either physical or emotional or economic hardship, and they somehow through courage and luck and aspiration and all those things overcome some great obstacles, like great moral and almost religious and sort of in its inception. So his story didn't have enough originality, and I gave many other examples that I found through history for him to say, I don't think your story is original enough to really say Finding Nemo ripped you off in any way, shape, or form. And how are you going to prove exposure? How did they know about your book? Although his book was published, so it could be that. So copyrights. Copyright protects the creator for the lifetime of the creator plus 70 years. I think that's the current status. Does it say that in the book? Yes, plus 70 years of the lifetime. So I'm going to date myself a little bit here, but I love old music especially from the 60s. And Sonny Bono, Sonny and Cher, some of you might have heard it. He actually wrote a lot of music for other artists, and he died many, well, I guess it wasn't that many, maybe 25 years ago in a skiing accident in California. He became a congressperson. But a lot of people didn't like his music as from himself, but some of the stuff he wrote for other people is fairly famous, and that's still protected because it hasn't been 70 years since his death. And a lot of people say, well, if it's so protected, why do I hear other people covering other artists? They probably purchase a license to do so. In fact, there's some controversy right now that some songs played by the Trump campaign, when he goes to an event, he'll play, I forgot which group, I think it's The Who. He was playing a song, I think, by The Who, and The Who said, you got to stop because that's copyrighted material. You don't have a right to play it. And it doesn't necessarily mean it has to be for commercial. If you own the copyright, you can ban somebody else from using it, whether it's political, at a party, or just generally speaking. And it comes up a fair amount of times that people try to, same with downloading music that's not you have a right to do necessarily. You might have a platform that provides for it because they purchased a license, like Apple Music or I forgot the other, iTunes, I think it is. Well, they're purchasing the license from these artists or producers of music. And, it can have a great deal of value. And if you violate those laws, it's actually criminal as well as civil. Interesting thing came up. I'm getting off track, but I do want to burn through the video. You don't have to listen to everything I say. Just put it on as background and pick up the stuff you need. But I always find it interesting how valuable copyright is. And at one time, Michael Jackson, the musical artist Michael Jackson, I believe, purchased all the Beatles copyrighted music. And then he said, why would they do it? Because they gave them a fortune, and they probably reserved the right to still play that music themselves. So you can do all kinds of creative things in contract law, like saying, well, geez, what if I create some really great song and I'm known for it? I'm like the Franks, you guys don't know Frank Sinatra is, but whatever, some big artist of today. I'm representing Beyonce, and she comes out with this huge hit. Can she sell the right to specific individuals? Yeah, and she can also retain the right to still use that and not sell it exclusively to somebody else. So copyright's a powerful tool. Trade secrets. Trade secrets are implicit. A lot of times, I don't hate using Kentucky Fried Chicken, but Kentucky Fried Chicken's recipe supposedly secret and it's been around for I don't know how many. Not quite a century, I don't think, but certainly decades and decades and decades. And they have this secret recipe. What if I was working at Kentucky Fried Chicken and I moved up through the ranks and became somewhat of management, and I had that revealed to me? Could I sell it to somebody? No. Even if I didn't have a contract that said I was barred from selling it, it's understood that trade secrets are owned by the possessor of the secrets, and any employee or agent must keep that information secret. They can't sell it for free or for a profit or disseminate it just for fun because it's protected. And trade secrets, I always think of back in the day when Kodak, I think, was big or it was a Polaroid that was big in Massachusetts at one time as a manufacturer. They had a trade secret on how to develop instant film. Now everything's instant, but back in, when I was a kid in the 70s, it was a big deal to have a camera. You take a picture and it would slide out and you can look at it 5 seconds, maybe not 5 seconds, certainly 5 minutes later. It would all be produced. Those kinds of technological processes are going to be retained by the owner, and employees and agents can't just go out and disseminate that information. Lost and abandoned property. Students in my regular brick and mortar class love to talk about this for hours on end. Generally speaking, if property is lost, the true owner retains title to it. They don't give it up because it's obviously lost. That's different than abandoned. So what if I don't know, I have some stuff that you might think is valuable, but I decide to throw it away and I throw it out in my curb, and I'm waiting for the trash company comes tomorrow, they're going to pick the stuff up, and you're driving along and you see something, an old bookcase or something, and you go pick it up. Can I stop you from doing it? Pretty much no, because I've shown the world that I had the intent to abandon title. Therefore, it is discarded. It is abandoned, and anybody is free to do that. And so that's why some people don't bring out their trash because they don't want people going through it. That's different than lost. What if this just happened to me the other. I love telling this story. I don't have a wallet, so I always carry my money, my credit cards and stuff, and IDs, all kind of like loose, like in a pile of crap. And I was really happy about a year ago. I found a $100 bill and two 20s right near my car after being in court all day. And I was like, oh, this is a windfall. And I said, I'll put it with my other money. And that was my money. I had dropped it earlier in the day when I got out of the car, and I am lucky enough to find it some 6 hours later. Didn't move very far because it was in a garage and it wasn't, apparently the air wasn't moving too much. But think about it. If you find some money on the ground, is that abandoned? Nobody abandons money, I don't think. Most people lose it. Now, the problem with cash is it's hard to prove you're the true owner of the item unless you know the serial numbers on your money. Nobody does. So I know finders, keepers, losers, weepers. And possession is 9/10 of the law when it comes to abandoned or lost property, but it is lost. If somehow, in some way, the true owner could prove that that's their cash, they have a right to get it back. That's true of anything else that's mislaid or lost as opposed to abandoned. And it's about the intent of the owner. What was the intent under the circumstances? What did it appear objectively? If I left my computer at Starbucks, I got up and I got busy, I got a phone call, I got to run to court, and I forgot I had my laptop out on the table at Starbucks. I clearly didn't abandon it. I mislaid it. I've forgotten it, and I have the right to get that title back. Now, sometimes people find things, kind of in the woods, or they've been there for many, many decades. The finder has the right to possess it against all except the true owner. In some states and some jurisdictions actually have a provision in some statute that if you bring it to either police station or town hall and they run an ad in the newspaper so many times, at some point they were considered title vested in you. But under the common law, under the general principle, the true owner always has a right to come back and seek possession back from you. That's in some jurisdictions changed by that statutory authority that if you bring it to the police department or to the municipal hall or some repository, do the appropriate advertising for a period of time and no one comes to claim it, you will get true owner that will allow you to sell, transfer, or manipulate the property any way you want. That's a rarity. Most of the jurisdictions keep it that the lost property is still owned by the true owner, but you have a right to possess and use it as the finder. Complicated area. I don't test too much on it. Bailments. This is a fun area. Bailments. Now this isn't bailments of come bail me out. I've been arrested. I got to come up with $500. Bailments are about possessing someone else's personal property. It can be anything. I'm thinking about my dog right now, and usually my dog sits right by my side during these little speeches. And Martha today is at the vet. She's having minor surgery, having a cyst removed from her back. So I own the dog. I am the owner of the dog, but I've given it the possessory interest to the Sturbridge Veterinary Hospital today to do a surgical procedure on her. I am the bailor. And I know terms throw people off so bad, but I'm the owner. Owner means bailor. Bailor is the one passing possession to the bailee, the possessee if you want to. So they are the bailee right now. And the question comes up, and that's all we're going to test on for the purpose of this, is what can they do with the bailed property and how much care do they have to provide during the time they possess it? Now, I'm going to pay $997 for Martha's minor surgery. I know she's going to bankrupt me. So they're receiving a benefit, and that's the question. What degree of care does a bailee owe the bailor in different situations? Now, this is a mutual benefit bailment. I'm getting something out of it. My dog's getting, I was going to say repaired, but getting treatment, okay? They're getting something out of it. They're getting $1,000. So we're both getting something out of it. Therefore, it's called mutual benefit. What degree of care does the bailee owe the bailor? The most common we find in law, a reasonable degree of care. They can't act reckless with my dog. But if my dog got hurt today, I'd only be able to sue if I can prove that they were negligent. Sometimes weird things happen that there was no negligence. Maybe my dog kind of got wacky herself and she got very excited and banged in a corner table and she injured her eye. If they were reasonable in the way in which they were handling my dog at the time, there'd be no liability against them. It's not an extreme degree of care. It's reasonable. And it all depends. It's contextual. And we all talked about that in chapter 3 about what is negligence. It's that failure to act reasonably under the circumstances based upon the duty that's been imposed upon you. And it's a debatable situation when it comes up. What about this? What if and this is happening at the end of August, my sister, her dog, Cujo, it's not the real name of the dog, but that's what we call it. It's kind of wild, kind of crazy, but she goes on vacation every last week of August, and I unfortunately always agree to take care of her dog because my dog and her dog are related, or allegedly. They're not related at all, but my sister thinks because my brother and sister that our dogs are cousins. Her dog's going to be over here for a week. I'm getting no money. I'm getting no benefit. All the benefits going to the bailor. My sister's the bailor. I'm the bailee. What degree of care do I owe my sister? I'm getting nothing out of it. None? Well, the law is always going to put some degree of care. I am going to have to exercise only slight care. So the little bit of a fencing I have in my back is kind of low. It's like a white picket fence. My dog is a golden retriever, and she abides by, put up a little tiny one. She won't jump over it because she just senses borders, and she's very cooperative and docile. My sister's dog, I watched jumped over a 6-foot fence like a gazelle. But I have that fenced in back in the area, and let's assume I walk out with both the dogs to the point where I get to this gated area, and I let them in the gate, take off their leashes, let them around, and the dog sees a squirrel. My sister's dog, I can't remember its real name now. Simon. Simon jumps over the fence, runs off in the woods, and tussles with a porcupine, comes back with injuries. Am I liable? I don't think so, because I was exercising slight care, and that's all that was required of me. I didn't do things to place her in imminent peril of a potential injury, harm, or death. I only owed her slight care, and that's all I gave her, and that's good enough, because all the benefit was flowing to her. I only owe a slight care. Now, if she paid me something or said, hey, as a result of you taking care of the dog for a week, I'm going to give you a gift certificate to Ponderosa Steakhouse. Are Ponderosa still around? I don't know. But Ponderosa Steakhouse. Now there'd be something going back and forth. Now my degree of care would open up to reasonable in knowing that the junk, now it's foreseeable to me because I know the dog jumps over low fences, probably a 4-foot fence out there. Then it probably would be a breach of a reasonable course of standard. And I always think of this other one too. I've got kind of a old cool car convertible thing that I have, and I don't drive it that much, but my 20-year-old son, he's got this girlfriend coming into town, and I can tell he says, hey, can I take your convertible? And I'm like, yeah, all right, take it. Am I getting any benefit out of it? No, none whatsoever. It's all flowing to the bailee. I'm the bailor. So it's the same as my sister's situation. What degree of care? Oh, I'm sorry, it's just the opposite of my sister's situation. Now, as the bailor, I get no benefit. The bailee gets all the benefit. What degree of care would you place on a bailee when the flow of the benefits entirely flowing to them? It's a high degree of care. They're almost acting as an insurer. If anything goes wrong, even if they were being very, very careful, you have to prove almost what we call a superseding cause or a fault of another to escape liability. Careful, I do have this on the test. So what if I told my son, I said, okay, you can take the convertible, you can take it from 6 p.m. to midnight, but it has to be home at midnight, and you're only going back and forth to your high school reunion. That's it. Taking her to the high school reunion party, and that's it. No drinking, no drugs. That's all you're going to do. But what if he says, all right, Dad, yeah, that's great. I'll do it. And he, along the way, drives extremely cautiously. He's very careful. Doesn't drink, doesn't drive, always within the speed limit. He's looking around so vigilant. He parks at that weird angle that people with fancy cars do, so no other car will park near them. Does everything. He exercises extreme care for my car. But he decides to keep it overnight and go to the ocean to watch the sunrise or some corny thing like that. And he still drives extremely safe and very cautiously. And while at the ocean, a drunk driver plows into my car while the kids are sitting on the beach. No one's injured, but my car is totaled. Now, everyone's going to say, I can sue that drunk driver, right? Yeah, you're absolutely right. But the question is, could I go after my son because he breached the terms of the bailment agreement? Yes. Anytime a bailee is given an object, they have to comply with the terms of the agreement and can't use it beyond or move it beyond or manipulate it beyond what the terms of the bailment agreement say. If they do, they are strictly liable. Remember strictly liable from tort law in Chapter 3, meaning there's no defense. You can't bring up the defense that I was behaving appropriately. Get struck by a bolt of lightning. Doesn't matter. You weren't supposed to be at the beach at that time. You were supposed to return the vehicle by midnight. That's a tough concept because I put one on very similar to the next test, a question about somebody behaving very appropriately, but they decide to do something beyond this. I'm giving it away right now, so hopefully you guys are watching the video. You can't use the goods beyond it. So those of you like Jerry Seinfeld, there's an episode of Jerry Seinfeld where he drops off a suede leather kind of jacket to the dry cleaner. That's a mutual benefit bailment because why? Dry cleaner's getting paid, Jerry's getting back a cleaner coat. What does Jerry notice? He keeps becoming suspicious that the dry cleaner is wearing his clothes out, out and about. I mean, he just gets suspicious. And sure enough, he bumps into the dry cleaner at, I think, either the movies or at a dinner party. And there's the dry cleaner wearing Jerry's suede jacket. And Jerry goes nuts. If there's any damage to the dry cleaner, no matter how careful he was while wearing Jerry's jacket, the dry cleaner would be liable. Why? He's breaching the bailment terms. He's not allowed to do that. Some of the other definitions related to bailment: the bailee must return the goods as they were received, and nothing can be changed on them unless the bailment agreement was to make a change to it. So what if I brought my car in today and I want new tires put on, or I want, I don't know, like flames painted on the side of it? Obviously, the part of the bailment was to change the nature of the product or the goods as part of the bailment agreement. That's obvious. It's pretty straightforward. So what do we know again? Just to go over the rule again. If the bailor, the one giving up the property, is giving it to the bailee for only their benefit. I'm going to drop off my car at my buddy's house today. He's going to put new brakes on for me. He's doing it as a gift. The bailor is getting 100% of the benefit. What degree of care does the bailee owe me? A very slight degree of care. It's debatable what that means, okay? What about this? Same example, but this time it changed a little bit. I'm bringing over the car to have my brake fixed at my buddy's house. He's going to be paid. I'm going to get some new brakes. Benefits flowing back and forth. Now, what degree of care does he owe me while it's in his possession? A reasonable degree of care. Now, what about this? Instead of him fixing my brakes today, I'm dropping off the car so he can go and look cool for the day in my convertible. He owes me what? An extreme degree of care. Okay? I think it's pretty straightforward. Oh, then the end of the book goes into the mutual benefit bailments that are considered special, like a pawn and a pledge. Both are very similar concepts, basically seeking a loan against the security interest in your property. So if I brought my coin collection into a pawn shop, that's why they call them pawn shops. I say, I don't want to sell this to you, although most pawn shops really are in the business of buying and selling goods. Some do still do pawns. So I say, I'm just a little short right now, but I'm getting my income tax return soon. I need $1,000 loan on my coin collection. Usually what that is a security interest. That's all a pawn is a security interest in some personal property of some kind. So they'll loan me $1,000, usually at pretty high interest rates, but it can't be usury. Remember from previous chapter, it can't be illegal rates of interest. So, but it's still in the higher end that the law allows. And then I have to pay back that loan within a certain period of time, and I get my coin collection back. That's a pawn. A pledge is related to that, but it usually relates to stocks or some kind of bonds, the intangible property that represents an interest in something else. Same concept. That's different than going into a pawn shop and simply selling your coins. That's nothing to do with a pawn. It doesn't have any kind of bailment arrangement there. Why do we care? Because a pawn is a type of bailment. Think about it. He's got my coin collection in his possession. Mutual benefit, right? He's going to make some interest off me. I'm getting to borrow some money. He has to owe me a reasonable degree of care while he's in possession of my coin collection. And then they talk about conversion of bailed property. Generally speaking, the bailee has no right to convert my property unless I asked him or her to. So what if you're having a tax sale? I used to have tax sales with my brother and sister when we were younger. And I always hated them. I'm very shy by nature, so I don't want to deal with people talking and trying to negotiate prices on things. So I always hid in the backyard when we had these things. I'd set up, but then I'd run. So say I had some things, I said, it's like, geez, it'd be great to have a tag sale, but I don't want to deal with people. I don't want to put ads out or anything like that. What if my neighbors have this huge tag sale? And I go over, or yard sale, whatever you want to call it, and I say, hey, can I bring over, I got some furniture, some desks, stuff. How about you sell it, drop it up, and you keep 20% of the proceeds. I get 80% because you got to deal with the people hassle. And, and here's the prices I want for the goods, but, you can negotiate up to 20% of the value in case you think you can wheel a deal. That's the type of bailment. That's called a consignment. And some of you can tell by what's behind me, some of my button collection behind me, I'm into political buttons. I often go to antique shops and look around. Usually the antique shop isn't just one antique dealer in there. They have different booths that different people rent. And there might be just one or two people working in that antique shop, basically having the power to sell other people's goods. That's a consignment. It's a type of bailment. And it's a reasonable degree of care because the consignor, the person who owns the actual goods, is giving it to the consignee, also a bailee, they're the same thing, and they owe a reasonable degree of care. You could change all those terms in the contract, though, because every so often I toy about this idea, like, well, I'd love to have an antique shop, hang around there on the weekends or whatever, just give me something to do, and when I collect crap, I can sell it there, and then I can sublet units in display cases within my structure, and I can have it a consignment. Could I put in the contract that anybody that sells goods through my store will hold me harmless if anybody steals their goods, if any of their goods are damages by consumers or just by natural events, a pipe leaks in my building? Yeah, you can always contract away these principles. This is if we don't have a contract that spells out who's going to be liable to what degree for bailed, consigned, pledged, pawned goods. Never forget that. You can always put in your contract that while I'm possessing your jacket at the play. I'm at some play, and if you've ever gone to one of these, I think the Worcester one has one there. You leave your jacket and you get a check and it costs $1 or something like that. That's a type of bailment. Can you put in the agreement that we're not liable for any lost, stolen, or damaged articles of clothing that you've checked there? Yeah, you could. That would be waiver would probably be upheld in most circumstances as long as it was clear and it wasn't in fine print. The one thing about conversion of bailed property, well, that's an allowance, that's a consignment. But sometimes we bail property and we make it look like to the world that the bailee actually owns it. I've actually done this in my own lifetime. At one time, I bought a snowblower, and my then wife was going to kill me if I bought a snowblower. So I brought it home, and I told her it was my friend's snowblower. And my friend actually did borrow it from time to time. So what happens if my friend borrows my snowblower? He's a bailee. I'm the bailor. It's my snowblower. But I've kind of told the world that he wasn't a bailee, that he actually owned it, and I was the one basically using it from the time to time. Now, if he sold it to a third party, that third party would get good title, even though I'm the true owner. Even though it's fraud against me, but not against the good faith purchaser that bought it from my buddy. Why? Because he appeared to the world to be the true owner, because I told everyone it was. In fact, I even wrote on the side of the thing in double marker his name and his phone number as owner to show a more convincing thing. So conversion of bailed property, if the public's misleaded to believe that whoever is currently possessing the item is the title owner, good title does pass to a good faith purchaser. And I don't think it's in this chapter, but it's in a later chapter called Sale by a Trustee. And I don't want to beat it to death on this chapter. Let me just look real quick so I don't miss it. Now, I think it comes up in a later chapter. I think it might be in chapter 15 or another chapter later on. But I might as well just mention it real quick. What if I brought my used watch? I don't see it, but I have a watch I have, and what if I go in and I want to get the battery changed and maybe the bezel scratched, and I want to get a new bezel put on there, and they sell new and used watches at the store. Whether it's accidental or intentional, if they put my watch out in a display case and had a $50 for this used Seiko, and somebody came in there innocently and bought it, they would actually get good title, even though I never gave up my true title to the item. Why? Because they're a merchant that sells new and used items of that like kind, and it's reasonable for consumers to believe they have the power to pass title. What my rights mean? I can sue them for the damages, meaning the watch company. I could sue them for the damages of the lost watch. But the problem is that Seiko I have doesn't have a lot of value. I don't know. It cost me a lot. I thought a lot when I bought it. There's about close to $200 for it. It's a diving watch. And the thing is, it has a lot of sentimental value because I bought it on a specific day that was very special to me. So I bought it on there. It doesn't have really monetary value. It's now 6 years old. And but the problem is you can't sue for sentimental value. And so that's the thing. Make sure when you bail your property to a bailee, the bailee is reputable and unlikely to either make a mistake or do an intentional act like that. Bit of a long video, but there's a lot of stuff in chapter 14, a lot of testable stuff that I think is straightforward though. And again, I'm going to advise you, take your time on the test, look up questions you have that about, read the test questions very carefully, because sometimes I think some people aren't reading a negative in the clause or a positive in the clause and are reading it inversely, but yet they understand the concept and they're not doing as great as they can on the test. So be very, very patient as you work through these tests. Otherwise, have a wonderful Thursday.